It's recording.
Yep, great, thanks. All right, I'll call the July 24th, 2020 Electrical Work Examining Board meeting to order. Let the record reflect that board members Peter Jennings, John Yusa, myself, Larry Valeries was in attendance. Tony Soder did call or text me this morning. Unfortunately, he's not feeling well, so he will not be able to join us today. We still have a quorum based on the 40% of those appointed, so we're good to go with our meeting. First item of business is to approve the minutes of our June 10th meeting. Everybody received a copy of them. I'm sure they had an opportunity to review them. Are there any questions or comments? If not, we'd entertain a motion.
I'll make a motion to accept.
I will second.
Any discussion? Hearing none, all in favor, indicate by
Aye.
Aye.
That's 3. Opposed? Abstentions? None. Minutes are approved. Thank you. Because we're having this July 24th meeting, we had asked at our last meeting that the DCP investigative complaint status report be provided at our next scheduled August 7th meeting. So we have no report for this meeting, which is totally understandable.
Mhm.
Okay. Before we get done today, while we're having our meeting, give some thought to this. Our next meeting is only about 2 weeks away. Then the following meeting is November 13th. Karen and I were talking earlier. We think that we might want to cancel the August 7th meeting at this point, being that it's only 2 weeks away, and maybe schedule it for sometime at the mid to end of September, kind of in between now and our November meeting. So we'll talk about that at the end, but just give that some thought as we go through. Okay, does anybody have any old business they want to bring up? No, okay. Let's see, Karen, who else do we have out here?
We have under attendees, the name I'm seeing is Evan. So if you want me to allow him to talk to see.
Yeah, I want to see if he can
Wanna do that?
identify himself. Yep.
Evan, can you hear us? He's unmute. He's
He's
muted
muted.
on his end.
Right.
It looks- Right.
Evan, your microphone is muted.
Yeah.
Oh,
I don't know anyone by that name.
Robinson and Cole from the law firm?
yeah, it was, okay. Evan Dantos from, who was it from? Robinson Cole? Okay.
The chat window says it is Evan Dantos from Robinson and Cole.
Yeah.
Just so for the record.
Oh, I didn't. Thank you. I didn't look at the chat.
There we go. Okay. We looked at everything else.
Oh, okay. Sorry about that. All right.
Okay. Evan, did you want to speak about anything that's not on the agenda?
Maybe if you wanted to type him a message in the chat, I'll reply back. If there's some kind of problem with audio or something.
No, he says just checking it out. No thanks, just checking it out.
Oh, yeah.
Oh,
Okay. I see it.
All right. Very good.
Okay. Well, welcome. Okay. And it looks like Terry had joined us.
Yeah, there she is. Good morning,
There
everyone.
she is.
Karen, why don't you reintroduce Terry for those
Right.
that weren't on here before?
everyone. This is Terry Jo Powell. She's our new license and application analyst. She started last week with the Occupational and Professional Division, and she'll be doing a lot of things, but one of the things is the Real Estate Commission, the Appraisal Commission, and maybe down the road some of our boards. So, so we're very happy to have her.
Good morning. It's my pleasure to be here. Thank you.
Welcome to DCP.
Thank you. I appreciate it.
All right. Before we get into new business, I just want to add one item here, item number 6 to new business. This is a email I got from Karen just the other day. We need to have somebody step down from the board for a compliance hearing with Stephen Hardy. Okay, so we will talk about that when we get there, but nobody has any objection. We're going to add that as item 6. Hearing none, let's move forward. Then under new business, review for clarification, the board motions for the following CE audit cases, okay? This point, everybody's received a copy of the spreadsheet chart that was put together for these cases. At this point, I think I will turn it over to Paulette.
Yep.
And
Thank you.
one by
So
one.
I wanted, before we get into these cases, there's a couple of things I wanted to address having to do with the CE audits. So as you know, based on our final decisions, your final decision in orders, compliance was due the end of June. And so the department made a decision based on the executive order, the governor's executive order 7M, to extend out the deadline 30 days to allow people to come into compliance. And so that was extended until coming, it will be this Saturday, July 25th. And so coming Monday, July 27th, we're prepared, I prepared revocation letters to the licensees. I don't know what the list is. I don't know how many people are on the list to have their licenses unfortunately revoked for non-compliance with the order. But yeah, the notices will be going out Tuesday, but in our system, we will be revoking the licenses on Monday, July 27th.
Paulette, Peter, did you want to say something?
No.
Paulette, I follow you with the compliance meeting date, as you said. What was the original compliance date? Because I know it took some time for us to get these FDOs out and so forth.
It was mailed out.
Did the clock
May
start?
26th. May 26th.
Okay, so the clock started after we got these out, basically.
Yes, May 20. Yep, as of the date of the final decision order. So, yeah, we've had people complying, but then we've had people that haven't complied, and of course we have some reconsiderations that we're gonna talk about today. But yeah, so I don't know the numbers as yet because I don't want them to run them until Monday morning, and I'll be in the office on Monday morning, so people have an opportunity, at least, you know, a couple more days to come into compliance.
Okay, yeah, I mean, that's what we all decided, so that's what we need to do, unfortunately.
And then we discovered when we were uploading the final decisions into our e-licensing system that there were 2 cases, 2019-1283 and 2019-1307, that were drafted by the AG's office that we missed. They never became a final decision in order. I don't know how we missed it, but we did. So those cases will be coming to the board for review. They just need to be, you know, sent over to you for review. And then final approved by the commissioner. And then there was another case I don't know why this one, there was not even a decision drafted for it, which is 2019-12-13. So Jerry, who's been so great, will be drafting that decision, and then it will go over to the board for review and then approval to the commission. So these were 3 cases that somehow we missed.
Okay,
So expect those decisions.
that's not bad. 3 out of some, almost 100.
Yeah, 3 out of 100. Yeah, that's true. All right, so why don't we go to the chart that I had created for cases for reconsideration, board modification, or reversal, and clarification. So we had received 2 requests for reconsideration, and under the Uniform Administrative Procedures Act, there is, under 4-181A, there is authority for the board to take action for reconsideration without even someone putting in their request for reconsideration. So there are a number of those cases that we had pulled because we think that they do need the board to make a vote as to whether you're going to reconsider. And right now it's just a vote. And once you decide whether you're going to reconsider, then what happens next is either I have to send out notices to respondents, or in some of these cases, there might not necessarily need to be a notice. So that's a decision that the board would have to make about these cases. So if we start with the first one on the list, which is 2019-12-47, Kurt Keith. So this is a case where we later found out that he did take the 2017 CE in 2017. He had provided the information to us, but it's one of those things, unfortunately, where the notation was not made. And so he ended up getting notices, compliance meeting notices, and he didn't show up because he thought everything was fine. And we later found out that he did provide that information. And so what happened was we did provide that information to the board, but this was post the hearing when the board had already voted on their decision for the $1,000 civil penalty and no makeup class. So at this point, the right process to rectify this, because there was a subsequent dismissal, but it has to be a board decision and not a decision by the chair post the hearing. So that's why it's brought forward today for the board to vote to reconsider the final decision, and then you can decide what you want to do, whether you want to modify. And this is the type of case where you probably don't need an additional proceeding, but right now you need to decide what you're going to do with this case. So you did get the information, so you know that he did have to do the makeup class, but it's how the process, how things ended up working, that after the board voted, then there was a dismissal, so it can't work that way. So we need the vote to, the board to decide to reconsider the decision, and then from there make the appropriate decision.
I have a copy here of his certificate, which is what we had, I believe, prior to at the beginning of that hearing. Okay, and I think that's why we said that there was no reason to do anything other than dismiss this. However, we have to go through those actions. We can go through those actions. I mean, there's no question that this person did take the class, and he did take it, took it on April 8th of 2017, according to the document. So I don't know how the board feels about that, my board members, but I'd like to hear from them.
Do we need to make a motion to dismiss it or just reconsider it? Or yeah, because if it's an administrative error, let's just rectify it.
I guess it's not clear whether it's truly an administrative area. Is it error? Is it, Paula?
Well, there was an error that was a personal error, an individual making an error. So it doesn't have anything to do with the process itself. And because, you know, there was a hearing on and there was a decision made. I have the minutes from the November 8th hearing, and there was, even though that certificate was provided, I don't see anywhere that was provided at the time of the hearing. Otherwise, I think the board would have seen that. I believe it was provided after, and that's why a decision was made on November 8th, because he didn't show up to impose the $1,000 civil penalty and no makeup class. It was after, post the hearing, that we provided the information to you when we found out that this was an error on, you know, DCP's part in not catching it. But that's why it has to be a vote to reconsider the final decision that was made. And then once you make that decision, then after you can decide, the board can decide whether they're going to reverse it, modify it.
Okay, so the procedure we should really take here then is to vote to either reconsider or not reconsider.
Exactly.
That's pretty much is that pretty much true on all of these cases?
That's all we're going to do today. And then the board will then decide how you want to take care of the case. So whether you want an additional proceeding or not, or you want to then, you know, I'm not sure if we need a written decision, or whether it's going to be a vote by the board to dismiss. I'm not sure yet. So why don't we at this point just do the voting on whether you're going to reconsider it, and then you can decide, you know, what you want, how you want to go about modifying or reversing the decision.
Peter, did you want to say something?
No, I'm sorry.
Okay. All right, so can I get a motion to for reconsideration of case 2019-1247?
I'll
Make a motion.
Or I'll second then.
Okay. Any discussion? All in favor? Aye.
Aye.
Opposed? Okay, motion carries. Okay, so we'll move that into reconsideration.
Thank you. So the next case, 2019-1244, Howard, Clay Shees Howard. This is a board motion for reconsideration. And this was another case where post the hearing, so there was a vote by the board to impose a civil penalty of $1,000. He did not show up. And then post the hearing, the board received information, the board chair received some information through the department that this individual was planning to retire or surrender his license or something to the effect. But let me just check my records. I don't think I've received a surrender from him. And I know that our occupational professional licensing division, Howard Osden, has been emailing this individual to get him to send us his surrender. And to date, I have not received anything from him.
I checked the online license lookup on him, and it shows that he has a T2 license that's lapsed. It shows lapsed. So I kind of do remember something about retirement, but again, I don't think the department's received anything on that. So again, let's take a motion to reconsider.
I'll make the motion to reconsider.
There's a second?
I'll second it.
Any discussion? All in favor, aye.
Aye.
Thank you.
Okay.
So the next case is So 2019-1209 Jackson. So this is a board motion to modify reverse decision based on changed conditions. So what happened in this case based on the meeting minutes was the board had voted that he would pay a $500 civil penalty if he showed proof of the 2017 makeup class within 15 days of the hearing. We did not receive anything to support that. And so there is nothing else in the decision as to what happens if he doesn't provide that information. And so right now, I think the board needs to vote to reopen the decision, to modify or reverse the decision, because there's nothing we can do. And then after that, then Jerry would draft the decision.
Okay. Again, I looked him up this morning, and that is the correct name, right? Alfred Jackson?
Yes.
Okay. And according to the license lookup, there's no record found for him.
Really?
Yes.
That's interesting, but he did show up.
Did in the complaint, did we have a license number for him?
Let me just double check, because it should be on here. Hold on one second.
Mm-hmm.
Yep. So he has an E1 0201549.
Okay. Well, two things could have happened. I either looked it up wrong, spelled his name wrong, which I was pretty careful.
Or called him by his, he has two first names.
Yeah. Yeah, right. That's a possibility too.
Yeah.
Okay. All right. Well, I just bring that to your attention. You can take a look into that a little further. We have a motion to reconsider.
I'll make a motion.
I'll second.
Any discussion? All in favor?
Aye.
Aye.
Opposed? Motion carries.
So this one, it's a vote to reopen the case, because now we have to, what happens next is he has to come before the board for a hearing because it's changed circumstances.
Okay. Is there a motion then to open this case based on Paulette's information?
I'll make that motion.
Second with a question.
Go ahead, John.
We're going to have them reappear now since we're not actually meeting. Will this reappearance be done over Zoom?
Zoom or Teams, I don't know which one it's going to be, but yes, they would be sent information as to how to join the meeting with audio and video, yes.
I was just concerned that this, on any of these cases, that they may just drag on for months after month after month, that's all.
Oh, no.
Okay, thanks, John.
Okay.
All in favor of reopening the case?
Aye.
Opposed? Okay.
So the next one, 2019-1299, Badness. So this is a board motion for
Oh, no,
reconsider.
excuse me. Which one's the next one?
2019-1299. It's right after Alfred Jackson. It's the
Okay.
very next one after Alfred
Okay.
Jackson
Yep.
on your list.
Yep, I was one ahead of you. I'm sorry.
Okay. So this is a board motion for reconsideration, and here is another one where the individual provided the department with evidence that he took the CE in 2017. And again, this is another one where the notes weren't made properly by the person taking in the information. And so, we missed it. I mean, there was a lot, as you know, a lot of cases. So he did show us that he did take it in 2017. He provided us with certificate. I will send that to you if you don't have it already. So he does have a 2017. He did take the class in 2017. And so this is a vote to reconsider the final decision because he didn't show up. He thought everything was fine. And it was a $1,000 civil penalty, no makeup.
Paul, I have a question for you.
Yes.
On these, any of these that we're reopening, in most cases, it sounds like it's something that was maybe overlooked by the department, like this one, or something that we had subsequent to the meeting, as you said earlier. Is it necessary that they have to attend for reconsideration? Because, I mean, let's be honest about it. If we've had the information and it was overlooked by the department, we're not going to penalize the license holder.
Right.
So, to John's point, okay, John Hughes' point, you're going to ask these people to take time out of their day to join a meeting, okay? Who knows when we'll get to them in the meeting schedule, but it shouldn't be too long. But is it really necessary to tell them they have to, that they should attend?
No, only, so the board has the discretion to decide, for example, for the board's motion for reconsideration, how to conduct the additional proceedings. So you can decide that you don't need the individual to come in, and then you can make your decision. The only ones that need to come in are the ones that we reopen. For certain they need to come in because you're reopening and you're rehearing the case.
Right.
Those are the ones for certain they need to get notice and their due process to come in. Otherwise, I will let you know the ones that, you decide what you want to do. If you need additional hearings, you might want additional information from us if you don't have it already that we'll provide to you. And then you can decide it on whatever papers you have.
Okay. Yeah, all right. When we get the bottom of the list, we'll probably make a blanket statement then about about the reconsideration ones. I just don't want to. This whole thing, for numerous reasons, has gone on for such a long time, and I really don't feel it's fair or proper to have to inconvenience the license holder when it's something that they're just going to sit there and say, I sent it in anyway,
Right.
Add it, and so forth. So,
Yep.
Okay. All right. So on 2019-1299, is there a motion for reconsideration?
Make a motion.
Okay.
I will second.
Okay. Any discussion? All in favor?
Aye.
Aye.
Aye. Okay, thank you.
So the next one, 2019-1227, Dinter. This is a board motion to modify or reverse the decision based on changed conditions. So prior to the hearing, he had indicated to the department his intent to surrender his license, but we didn't receive anything from him. We just received something from him. So the board had decided to impose a $1,000 civil penalty with no makeup. And so subsequent to the hearing, we did receive his, so this is dated June 2nd, 2020. We received a letter from him and a copy of his voluntary surrender. So this would be a vote to reopen or modify or reverse the decision.
Okay. And what license number is that for him?
So he is, so it's 01-84021. It's an E2.
That's his E2, which is inactive right now.
Yeah.
And there's a note on the on that file that says does not want to redo. Okay.
Yep.
Okay. And he also had an expired application for an E1, so that's fine.
So he is living in Florida.
Right. Yeah, I think I did see that. Pensacola, I think, right?
What's that?
Is it Pensacola? Not
I'm not
important.
sure.
Not important. All right. So we have a motion.
This is to reopen, to modify or reverse the decision.
I guess to modify the decision. Where decides to reopen. If we can modify that, we can do that here today now? Or do we have to set another date for that?
Yeah, I think it's just cleaner just to make your votes today, and then you're gonna have to decide what you want to do. I mean, you have to hear or see the documentation.
Yep.
To decide, where you're going with it.
Okay.
And we have to remember that because everything's remote, this is the great thing about virtual. It doesn't matter where you are in the country.
Right.
People can attend a virtual meeting.
I'd entertain a motion, I guess, to modify, let's say to modify, which could be a reversal too.
Yeah, first it's to reopen, because you have to reopen the decision first. You have to vote to reopen it.
Okay. Is there a motion to reopen it?
I'll make that motion.
I will second it.
Okay, any discussion? All in favor?
Aye.
Aye.
Those, okay, motion carries. Reopen.
So the next one is 2019-12-12, Aponte. So this is a motion to clarify what I call ambiguous decision, because I'm only calling it that because at the hearing, there was a vote by the board that there'd be a $250 civil penalty, and he was to provide a copy of his certificate makeup class within, I think it was 15 days of the hearing, which he did, but it would not change the fact that he would still owe the $250. And I think what happened was it was dismissed, meaning that there was no penalty. This was subsequent to what the board had voted to do. So there needs to be a discussion about the post-hearing decision and to clarify what the board's decision is. So at the hearing, the vote was $250 plus certificate. He provided the certificate, but then the case was dismissed, which would mean that he would not have to pay anything.
I don't remember, when we made those $250 civil penalties, and if somebody had to provide a certificate, I don't remember, I thought that was all we were requiring, and there's no such, we weren't looking to dismiss the case because the case was still existing. It was just that those were the requirements. And if they didn't comply with that, then there was action to take on their license. Peter, do you remember anything? John?
I thought the 250s, I'd have to look at the other ones, but I thought the 250s were ones where they didn't take the course, but then they went and they redid it. They didn't show up for anything, but they had just retaken it. And they didn't show up for any of the,
Compliance.
and they just came in with it right before the hearing that we had. I thought that's why we did the 250 on that.
If I remember correctly, I believe the 250, again, for anyone was the penalty for not taking their classes when they should have taken them. And then the other requirement is that just to pay the $250 and figure I don't have to take the class, we're requiring them to take the class. And correct me if I'm wrong on that.
I agree with both of you actually, because I think you're both saying the same thing. But I don't remember anything about dismissing it or anything of that nature, so.
No, I don't.
If they came in with a certificate that did not waive the $250, they should have taken it during the period of time they were supposed to.
Right.
What was the date of the certificate? Do we know?
I don't remember what the date was, but it would have, I think the board had decided that there was a window of time in which they thought it would be reasonable for them to have taken the makeup class, and it might have been in July of last year or something like that. Don't quote me, but I think the issue that happened with this case, why we're looking for clarification, is that he was present. He did come to the hearing, and he said that he had his certificate for the makeup class, for the 2017 class. So that's why 250 was imposed, but he had to provide the certificate to me, which he did. And so when I gave or sent the copy of the certificate to the board, for some reason, the case was dismissed. That's what the note says in the minutes, that it was dismissed. So that's why we need clarification, because I didn't understand that any of the cases would be dismissed when they provided the certificate. The 250 should still be paid. So that's why it needs clarification.
Yeah, I think we'd need to look at that certificate and everything else again to see.
See the dating on it?
Yes.
Yeah. Okay. So do we probably could just vote today to reconsider with that information. I mean, we need to have the information so we make an intelligent decision, I think. Can you raise it?
And so this isn't about reconsideration, but it would be for the board to clarify whether whether dismissal was a correct action post hearing, or whether he still owes the 250. So I will send you a copy of his certificate, because I'm certain I have it. So I will email that to you so that you can decide whether the intent was to dismiss it. But again, this was post the vote of the board that this case was dismissed, not by us. This is what I have in the notes from the meeting, the minutes from the hearing.
I would have to pull all my notes too for that.
Okay, so I will provide you with a copy of his 2017 makeup.
Okay.
Question, did he have that certificate, or did he take the class prior to the meeting, but he did not bring the certificate? Is that part of the issue here?
Yes. And then he
So-
provided it he was supposed to provide it to me, which he did, and then I provided a copy to the board chair.
Okay. Yeah, I think we need to discuss that.
Okay. And so the next case is the same scenario, 2019-1286, which is Sebastian Sanzaro. So again, this is a motion to clarify the ambiguous decision because the board voted unanimously for a $250 civil penalty at the hearing, and he was to provide a copy of his makeup certificate, which he did provide within the 15 days post the hearing. And I did provide a copy of that to the board chair. But then there was a decision to dismiss the case, which would mean that he wouldn't have to pay the $250. So it's the same situation with this case.
Okay. And I have a copy of that certificate. And the course was taken March 22nd, 2019. It was after the period.
Is that the correct date, Larry?
Pardon me?
Is that the correct date?
For the certificate?
Yeah.
Yeah. Course date, March 22nd, 2019.
So that was a makeup. So
Right.
yeah. So he took a makeup within the window that it appeared that the board had a window of time in which they thought it was reasonable, and that's why it was 250 versus 500 versus 1,000 is what I remember from the hearing.
Yeah.
Correct.
Yeah. I agree with that, Paula.
So so you can discuss at this point what the clarification is. Are you dismissing this, or is he paying the 250? That's the discussion.
my opinion, I think our intent was that he pays the $250 and he had to do a course, a makeup course. And if he's satisfied, if he submitted that information to you, then it would satisfy the issues.
He would still have to pay the $250, correct?
Yes, that's what I did say.
Correct.
That. Yeah. Yes, absolutely.
Other than that, they're taking an $80 or $90 course, and not the $250 on the same course they would have had to take anyways.
Right. So I don't know that we, again, you've got more paperwork in front of you, Paulette, but I don't know that we would have voted to have anybody pay a penalty and take a certificate, take a course, I should say, and provide a certificate. And as long as they did that, it would satisfy. We might have said dismiss it at that point. Yeah. We might have done that too.
So just so I understand, what is the clarification that the board is making with respect to the decision? So there is no dismissal and the 250 stands, is that correct?
That would be correct. And yeah, I mean, my opinion, if you're going to dismiss the case, you're not asking them to do anything.
Right.
Okay. So how can you ask them for $250 as a civil penalty, require them to take a course, and then say we're dismissing the case?
Right, but and that's the thing, and that was the issue when we went through these cases and looked at the minutes. This is why we needed the board clarification, because in the minutes it showed that the board had dismissed the case, and so we wanted to come back and say, okay, was that what you're intending to do? Because there was a vote for a 250 penalty, so that's why we needed the clarification.
I don't, and Peter, John, hop in on this. I don't believe our intent was to dismiss these cases if we issued a fine and asked them to do something in addition to that, or even if we only issued a fine.
Okay,
Right,
great.
I agree.
I believe it was the fact that the fine was going to be there, but they were going to have to take the CEU course rather than for the cost of the fine. They didn't have to sit through the class.
Right. And they had a certain period of time they had to do all this by, and if they didn't, then there's a possibility of suspension and revocation.
Right.
Yeah, there was further action was going to be taken if they didn't do it.
Correct.
Correct. Yeah. Okay, thank you.
So so there's no dismissal on that. Okay.
Yep. Thank you.
So was that the clarification that would go in the minutes that there was a penalty ordered, but there was not a dismissal ordered by the board at that meeting? Is that what we're looking to correct and put in the minutes?
I would say that it would be correct to say that we did not intend to dismiss the case, that there was a $250 civil penalty and a requirement to take a course.
Okay.
And Paulette, I would tend to say that the one we did just before that, 2019-12-12,
Yes.
I would think that was, again, the same intent by the board, unless the board feels differently. So if the board agrees, I would say 2019-12-12 also would be no dismissal. Would you agree, board?
Yes.
Peter's muted.
Oh, yes, I agree also.
Okay.
Okay, thank you. So the next case, 2019-12-80, Privé, I should say. he had made a request for reconsideration, and I had spoken to him to request additional information because he sent a letter.
Excuse me, Paula, was that after the hearing?
Oh, yes, yes.
Okay,
So
okay. All right,
after
thank you.
post-hearing, we had sent a cover letter that informed the respondent of what their appeal rights are with respect to reconsideration. If they want to go to Superior Court, they need to get a private attorney, et cetera, et cetera. And so they had 15 days in which to respond. And he did respond within the time period. And with request for reconsideration, it's very specific as to what needs to be provided in order to, for the board to consider whether they're going to grant that request. And so Howard Osted had tried to follow up with him, and then the respondent called me. I spoke with him and I said, you need to provide information, because in his letter, he just said he's requesting reconsideration. He has information that would support it. That's not sufficient for a request for reconsideration. So I said to him, you need to provide whatever information you're saying that you have, please provide it to me by last week. And I have not received anything from him to support his request for reconsideration. So it's really up to the board to decide whether you're going to reconsider the final decision. So it's a vote to decide whether you're going to reconsider it.
Again, a question for you. His license number
So his,
in class?
let me just find it. So he has an E2. It's 0188123.
Okay. All right, because I did look him up also this morning, and his status is a lapsed license at this point. He had also applied for an E1, but the board had denied him. And he's listed as Raymond Privy III for some reason, but it didn't come out that way. But that's how his license was listed. So, well, he could join into a Zoom meeting from anywhere, like you said. So,
Yep.
Let's give him an opportunity to present what he's got. Let's
Okay.
make a motion to
To reconsider?
reconsider.
I'll make the motion.
Okay,
I'll second.
all in favor?
Aye.
Opposed?
Opposed?
Peter, you're opposed?
Yes, I'm opposed. He did not submit any information for reconsideration. I say that our decision stands.
Okay.
I believe that's the way we would vote for that.
Okay. I would agree with Peter on that, because Paula did say he was supposed to submit some stuff to her. Has not done that as yet, is from my understanding. So,
All right, let me change my point here in view of the fact that this was not presented in a timely fashion as requested.
okay.
I will oppose.
Okay.
Okay, so that's to deny. Okay, his request. Okay.
For not submitting it in timely to you.
Yep, untimely, yep.
Great.
All right. So the next one is Eric Martin. So 2019-1258. So at the hearing, he had claimed, so this is a vote to reopen the decision. So he claimed at the hearing that he did take the 2017 makeup class, that he paid us $250. We went, we checked. We have nothing from him, nothing. So what the board had voted was that if what he said was turned out to be true, then it'd be the 250. If not, you would reopen.
And there are two Eric Martins listed.
Yeah, okay.
I'm assuming this is Eric A.
Let me just double check. 1250. I don't have I don't know what his middle initial is, but his license number, it's an E2 0201596.
Okay. Then that would be Eric J, according to the license lookup for that license number. And right now his license is lapsed. The one that I indicated with the initial A was an active E2. So I entertain a motion to reopen.
I'll make that motion.
Okay. Is there a second?
Question, why reopen it on this one? What makes this specific?
There was no decision made. There was no written decision on this case. So the board had voted that if what he said was true, then he would pay, they'd accept his payment. And if not, it's right here in the meeting minutes, the case will be reopened. So the board had voted they would reopen it anyways, because there was no penalty associated, because they were taking his word for it that he did do everything that he said.
And at this point, he has not provided that document.
We couldn't find anything. We had no record of him paying us $250. We had no record of any makeup class, nothing.
All right, understand. Thank you.
You're welcome.
I will second.
Okay. And I can just confirm that too, even with some emails that Paulette had sent me back in November 13th, as a matter of fact, because they were trying to get that information. So, okay, all in favor, reopening?
Aye.
Aye.
Okay. We'll
And
reopen.
this would be one where he would get notice of the hearing and for him to come, and then Jerry Padula would be drafting the decision.
Okay.
And there's one I need to add. I apologize. Are we done with that one? So I
Yep.
don't want to interrupt you.
No, yeah, that's no, we are.
Okay. So there's one that I forgot to add, which is 2019-1239.
Hold on.
This is-
hold on.
Yep.
2019.
1239.
Yeah.
Chris Gray. And he, his letter for reconsideration is dated June 6th of 20. So, based on the governor's executive order, we can extend, if it's untimely, we could extend that time period to make that request for reconsideration, but it's up to the board. So I can send you a copy of his letter. In his letter, he does say that he'll pay the $1,000 fine, but he's also asking for reconsideration of the board's decision. It's just a letter. I didn't follow up with him to ask him to provide anything, because I'm not sure what he's really saying is the issue, but that's up to the board to decide, not for me to decide.
interesting. He's willing to pay the $1,000 fine, but would like us to reopen the case, reconsider it. That's weird. Did he give a reason why?
He said, so things in the letter, you know, I think it's more on compassionate grounds based on, you know, the kind of work he's doing now. I can read it if you'd like. It's up to you.
Sure, go ahead.
Okay.
Not too long.
No, it's not too long. So it's written to Julianne. Dear Julianne, I'm writing this letter in hopes of reconsideration of the board's decision. I've been in the trade since I graduated high school, Norwich Tech, in 2002, and have only worked with one company, Wayne J. Griffin Electric. For 18 years, I love what I do and have grown tremendously in my company. I'm a foreman, crew leader, and a teacher. I love to teach the new apprentices, which are declining in numbers. The industry alone is declining in numbers, and I would hate to leave over my negligence of a 4-hour course. I'm truly sorry of my negligence, and I know there is no excuse, but losing what I've worked so hard for over the past 18 years sickens me. I went through a rough divorce, which beat me down over the past couple of years. I'm a father of 2 little girls, and the revocation of my license will affect them, me, my company, and the men I work with. And I see that now I'm personally doing well now and have financially caught up with the backlash of the divorce. I will pay the $1,000 fine to put this in the past. I have a solid 20 years left in me in this trade and would love to keep building these projects throughout Connecticut. Thank you for your time. Chris Gray.
Okay.
So technically, I mean, under the request for reconsideration, I mean, there are 3 things that you would have to look at, but first you have to vote whether, you know, you're going to reconsider the decision, grant him a request for reconsideration of the decision. So it'd have to be grounds would be an error of fact or law that should be corrected, where there's new evidence that has been discovered which materially affects the merits of the case and which for good reasons were not presented at the hearing, and or other good cause for reconsideration has been shown. So those are the only 3 reasons. So
I have a question on that one.
Yep.
Considering if I heard what I think I heard correctly, that this gentleman has been in the industry for a while. He's also teaching. How did he end up with $1,000 fine, which is kind of a stiff fine for somebody who didn't get a CEU or to that point? What's more background on this thing?
I think he didn't show up for anything. He didn't show up for compliance meeting. He didn't show up for hearing. He just didn't show up. And and we never received a certificate from him. And my understanding was that was the civil penalty with no makeup for everyone that just didn't show up, didn't provide anything. That seemed to be from the decisions, what the board was doing.
Right.
Okay, so basically a total disregard of anything dealing with this, which is a good way to teach somebody.
And he just didn't show up.
I guess the only thing I'm thinking, I mean, that his argument might be, because he did say he was going through a divorce for the last couple of years. If he was receiving the information to the correct email, I mean, the correct address, if he had moved or something like that, and it's just this big assumption on my part. But
Yeah, we didn't have anything returned.
you
Yeah.
didn't.
No.
Well, that doesn't necessarily mean it didn't get there, and
But he's still working.
out of spite it wasn't forwarded or something. Who knows?
But he was still working for a contractor, and he was at the time, and being a foreman and all that with his guys on the crews taking their CEUs and all that. You know, that's you know if you take it or you don't.
Yeah, I didn't hear anything in that letter that Paulette read that would give me a reason to think we should reconsider.
That's your decision, and I will just, you know.
I agree.
Okay.
Just that one word in there where he's teaching people, that's the one that gets me.
do as I say, not as I do. So, okay, so there a motion to not reconsider and not reopen?
It's
I
to
will
deny
make
the
that motion.
reconsideration.
I will make that motion.
Okay,
I'll second it, that we deny the reconsideration.
okay. No, any other discussion? Okay, all in favor?
Aye.
And would it be based on like not having information? What would it be? It's just a letter.
Yes,
Can we just make it that our original decision stands?
yeah,
Well, you first have to deal with his request for reconsideration, so you have to, decide whether you're going to, it's, just so you know, like, a request for reconsideration, that's all it is. It's not, person's not entitled to it, like, meaning that if the board decides they're not gonna reconsider, grant that request. Usually also, for example, a request for reconsideration, if it sits for 25 days, it's considered a denial. So in this case, he sent it in June 6, 2020, May was 26. So it would be within the 15 days, if my math is right. Jerry, you can correct me. So I guess the question is, if it's timely, it doesn't mean you have to grant it, but you have to have a reason for not granting it.
I think one reason could easily be that the reason why we don't want to reconsider it is because he never responded to any other request to attend a compliance meeting, or there were numerous other mailings that went out to the license holders that they were in violation, and
Right.
no response.
But that would be not fitting with respect to, the reason to deny, because for requests for reconsideration, they have to provide information for these grounds. And so if you find that these grounds have not been satisfied in this letter that he wrote, then you can deny the reconsideration as untimely because he didn't provide the information.
There's no extenuating circumstances in the letter, so.
Right.
And he didn't submit any evidence.
No evidence. I have nothing. All I have is the letter.
So can we say that as he
Yep.
submitted no evidence for reconsideration?
Yep. You can say it's untimely because, it's not complete. There's not any information in there.
Okay.
Okay. So,
And that was the last that I had.
what was that?
I don't have any other cases.
Oh, okay. Okay. Let me just take a look at these again. I think in any of these cases that we talked about, Paulette,
Yes.
as we discussed that on
Let me know which ones you want me to bring before you guys. Why don't we do it that way? And then and the ones that you don't need them to come back and you're gonna make your decision based on the information they sent, then you don't have to have them come back in.
okay. Let's take a look at them again. I think on 2019-1247, that's the first one. I don't think we need that person to attend.
Okay.
Again, because it's there may be some administrative
Yeah.
issues. 12:44, I guess he should still attend.
Okay.
12:09, we're reopening, so he's got to attend. 12:99. Again, an administrative thing, I think, so I don't think he does not need to attend.
Mm-hmm.
Next one is to reopen. The next two, we said there's no dismissal, so there's no reason to attend.
Okay.
1280, we denied. And 1258 is reopening, and 1239, one that you added, is denied. So,
Okay.
yeah.
Okay, so for that, we're gonna send out notices for them to attend.
I mean, they can attend if they really want to, but they don't necessarily have to. You know what I'm saying?
Yeah, but I have to send out, I'm gonna send out notices so that they know that they have a right to attend. They can attend to, you know,
exactly
put forth their case, answer any questions you might have, because a decision has to be rendered.
Okay. That's fine.
Which are the four that are gonna attend? 1244, 1409,
What was that again?
1227
1220.
and 1258.
What about 1299?
1299 does not have to.
Okay, so 1244, 1409, 1227, and
What was that other number you had? So I have 1244,
right?
1209, 1227, and
Yeah.
1258.
Okay. Okay,
Correct.
Thank you.
thank you.
Right. Paulette, you have anything else for us?
No, I don't. That was a lot. Do you want more?
What have you been doing with all your spare time?
Oh my God. In a few short words, plumbing, CE, audit.
And I guess that, Jerry, you're going to be writing up the FDOs?
Yes,
Yes.
I will be.
Okay, great. Okay, so that got settled over the period of time. Sorry about that, Jerry.
Yeah, the
Kind
AG's
of,
office.
yeah, interim. He's
Okay,
doing it interim.
okay.
We love him for it.
Yeah, thanks. I also have a whole flood of lemon law cases that are scheduled, like 10 of them up through September. So that's going to be very busy.
Yeah, sounds like it. Good. Okay, thank you. Thank you, Paulette.
Thank
Appreciate it.
you.
Okay. Moving on through our agenda here. Under new business, item number 2, Governor's Executive Order 7GGG, triple G. This is the order in which the governor extended the time to complete our continued education through the end of the year, December 31st, 2020, in both online scenarios and in-person scenarios. I don't know if anybody had any questions about that. I didn't think so. Yeah, and you have a copy of his order as well. Item number 3, discussion and recommendation to the Commissioner of DCP to modify the wording of the applicant's license renewal question relative to having completed a continued education. In view of the fact that we are going to allow them to complete their continued education by the end of this calendar year, and yet license renewals are due in September, October, there would be no penalties for people renewing and then doing the continuing education afterwards. By the same token, we want them to renew on time. So, as everybody knows, there's a question when you renew your license. It's two questions. One, have you been convicted of a felony since your last renewal? Yes or no? And the other question is, have you taken your current continued education since your last renewal? Yes or no? Unfortunately, somebody renewing their license, that's not going to take it because of scheduling purposes till the last quarter of the year. Can't really answer that question too well. So I know the commissioner spoke about, and I've spoken to the commissioner about rewording that question a little bit, and has indicated that IT will work on that. But I think she would like a recommendation from us to do that, just for the record. So I would entertain possibly that the wording be changed to something along this line, that have you or will you complete your continued education for this renewal by December 31st, 2020. No need to put a lot of explanation into it, because I think they'll understand that as they go through all this, their schooling and whatnot, and they haven't figured that all out. They've been raising that question out there in the industry anyway. So, but I don't want to leave that question the way it is on the renewal, because it kind of traps them into not knowing how to answer it.
Keep it simple.
I agree. It should be corrected.
I mean, it'll probably it'll be corrected for this year and then go back, no doubt, for the following year, but that shouldn't be a big deal for IT to do. So, does that wording sound okay to you, or something similar?
For me, I'm comfortable with it.
Karen,
I am too.
Karen, you got that probably through the tape anyway.
Mhm.
Okay, great. Okay, super. Item number 4 is just a reaffirm of our email approval vote for the 2021 continued education curriculum for both limited and unlimited licenses. As you know, everybody received that. We looked at it. We made some changes and corrections, and then modifications as board members felt necessary. So I just wanted to get a motion to accept the 2021 continued education curriculums for both limited and unlimited licenses as previously approved by email.
I'll make that motion.
I'll accept, yes.
Okay. All right, all in favor?
Aye.
Opposed? Okay, motion carries. That information is already posted on the website, so providers are aware of it, and they've been sent a letter from Karen indicating that it's available for them. Next item is an email, which everybody has a copy of, from Chris Brown, who is the training director at the Hartford JATC, and letters regarding continued education requirements. And his letter was dated July 6th, and what he was basically saying that they purchased X dollars worth of books as normally used in an in-person class. They spent quite a few dollars on those, which we understand. However, in that regard, nobody saw this pandemic coming on either side, so a lot of people are in the same misfortune. And they still have the opportunity to run online. I'm not right, excuse me, run in-person classes. Again, he did some calculations and stated that he has a problem in getting all of his people trained. Recently, Richard and I got a letter from him indicating that he was entertaining, and they spoke to the Hartford Yard Goats to rent the Hartford Yard Goats Stadium for their people, which would fall all within DECD requirements for spacing and so forth. He was still working on some details with them, and he figured he would probably he wouldn't have 400 people in that stadium at one time. That would be, first off, it would exceed the gathering requirement. But he's got about 400 people to train, and he was thinking he might have like 3 or 4 classes there. And he was working on that. So he was due to get back to me with some questions I had for him relative to the actual operation of how he would operate it in the Yard Goats facility, and how he would, how the license holder would be able to ask questions back and forth as well. They were talking about doing microphones and speakers, additional speakers and microphones around the concourse where they'd be seated. So I don't think there's anything we need to really discuss on this at this point. I'm trying to work with Chris in accomplish what he's trying to do, which I think is, for all intents and purposes, it's doable. It's considered an outside gathering. So he could, at this point, he could have up to 100 people in there. There was some question whether that 100-person gathering, according to DECD, was for social or business. Okay. And that was one of the questions he was going to be checking with them on. My opinion, I don't think the pandemic and the virus has much of much does it care whether it's a social gathering or a business gathering. It's going to get transmitted. So
Question, Larry.
I don't think that's a problem. Yes.
I don't think we've ever established, but just food for thought, on how large a class can someone actually run with one instructor, 2 instructors. As you mentioned here, people have questions, and the larger the mob, the harder it is to get your point across in the time allowed. I don't think it's anything we need to discuss now, but we might want to visit it sometime in the future.
Yes, and I totally agree. And if you recall, even in our minutes or in our agenda from last month, or the last meeting, I have an item there. We're trying to keep carrying forward to the appropriate time to discuss reviewing the continued education requirements in total. That being one of the items in particular, how many students per person, per teacher, what's effective and what's not effective. So yeah, I agree with you. It's something that we can't apply right now. We have no restrictions on that other than on the following the DECD requirements for in-person and following our requirements for the online, which is limited to 25. So I will continue to work with Chris on coming up with a resolution. I don't think it's unreasonable what he's coming up with. He did indicate that it would probably be at least 2 instructors maybe over there, and he would probably have a couple other people, I guess, as runners, maybe for purposes of, I don't know what purpose, because he didn't have this program all put together. But I thought it was a creative idea. So, if anybody's got any comments on that, I'll take them, but pass them along. But for the most part, all the providers that are have been trying to do it online and do in person. I don't think anybody has had an online class that I'm aware of yet. I think the earliest ones are in August right now. And I do know that the provider down in Norwalk held a course at a facility, kind of like a banquet facility with outside tents and whatnot. He had about 60 people there. And I spoke to him yesterday and he said it went very well, actually. It wasn't much different than being in a classroom from his perspective. And he had a lot of questions back and forth. And again, he's not crazy about online, so that's why he's trying to do it that way. So there's people are actually getting creative on how to do some of this stuff. All right. I'll keep you updated on that issue for Local 35. I haven't talked to Paul Costello down at 90 to find out what he's doing, or how he's trying to handle it, if he's got any problems. But as you know, we hear a lot of testimony from them that too many people to get done in a short period of time. Well, it seems like people are starting to work that out. So we may find that there's a problem as we get closer to the fall. Let's give everybody an opportunity to at least try, and maybe we have to do something a little different come fall for people. At least if we can get it completed this year, then we can hopefully, let's assume that next year will be a normal year for doing business, and we can all start off 21 with the new continued education classes the way we normally have. Okay, I added number 6 to the new business, which was I got this email the other day that we need a step down person from the board for police compliance meeting against Stephen Hardy, which is case 2015-138. So looking for a volunteer.
I'd be happy to do it. I did the other ones. So.
Okay, great. Thank you. Peter Jennings will do that, Karen.
Okay.
And you pass that along to the legal division so they can.
And Larry, can you just a reminder that whoever steps down for the compliance meeting has to recuse himself if it goes to hearing. I know Peter understands it, but I just want to make sure it's on
the record.
Yeah.
So stated. Thank you, Paulette.
What she said.
What was that?
Ditto what she said.
Yeah. Yeah, ditto what she said. Okay. Last but not least, is there anything else that anybody has to bring before the board today? Okay, I'd like to just talk about our next meeting, which is scheduled for August 7th. We talked about that earlier in the beginning of the meeting. I'm thinking that maybe we should be looking at the latter part of September. That would give some of our providers a chance to, they're doing online that I hear starting in August, opportunity to report back to us on how they're doing. We don't have much of anything right now in front of us for August, as it looks like. So I'm thinking September, if we stay with a Friday, Karen, is that still good for you?
Yeah.
We got a choice of the 11th, 18th, or 25th. Does anybody have any? I doubt anybody has any vacations because school will be back in session and everybody will be at home teaching their kids again.
Yeah. I'd say probably closer to the 25th because then that spaces it out more evenly between our November meeting and this meeting.
Okay.
Either date works for me.
Okay, so we will cancel the August 7th meeting. And we will schedule a September 25th meeting. And if you would let, even though legal division's here, let legal division know that the quarterly report won't be ready for us for August 7th because we won't have the meeting. It'll be September 25th. Okay, anything else for anybody? No.
Nope.
No. Well, Terry, how did your first meeting go with us?
Very good, thank you. It's very informative.
Welcome to the department.
Welcome
Thank you
again to
very
the department.
Yes,
Thank you
I
very
forgot
much.
to, I forgot, I need to just, one thing I forgot to say is that for the denials of the request for reconsideration, there needs to be a letter going out to the respondent, and I don't know who's writing that. I don't know if Jerry's writing that. I don't know who's gonna write that, whether I'm writing, Jerry says no. So I'm gonna check with Julianne, who's writing that letter. It could end up being me writing it and you signing it. I'll just find out from her who's writing those two letters denying the request for reconsideration.
Okay. I doubt that it will come out of the attorney's office, attorney general's office at this point, and
Well, it will not be coming from them.
which is amazing. But since Jerry does such a good job, I would certainly have no problem with him writing it.
Thanks for volunteering me.
But
We have lots of templates.
yeah, I was gonna say, you must have a template. Somebody's got a template.
Oh, we do. We have templates for it.
Okay, very good.
Yeah.
Okay, nothing else? All in favor, dismissal, adjournment? Motion to adjourn.
Make a motion, we adjourn.
I'll second it.
Okay, meeting's adjourned. Thank you, everybody.
Have a
Thank
good
you.
weekend.
Have a
I'm
good
sure I
See you
can
later.
write those, Paulette, I'm sure I could write those for you if you want.
What was that again? What was that again?
As long as I get a template of some kind, I don't know.
Yeah, I got a
I
template.
never wrote that letter before. I don't know what it would be, but
Yep, I have a template I can send to you.
I'm sure it's fine, whatever.
Oh, thank you, Jerry.
Just
Thank
got to
you.
remember to change the names. All right, thanks. Thank you, everyone.
Right.
Thanks, Karen. Have a great weekend.
Thank you.
Bye, you too.
Yeah, bye-bye.